Good morning, everyone. Welcome to our session on product risk for TCSPs. My name is Mr. Lamini from the FIC, and I'm joined by my colleague Philip Langenhoven, who will be taking us through the presentation for today. Please be aware that you've just posted attendance register. Can you please just complete the attendance register a bit later? We will post a questionnaire where we will ask you to complete some few questions for us, just testing your knowledge on the FIC and then how maybe we can make things better on these presentations. So Philip is someone who has more vast knowledge on ML, TF and PF related issues. And without any further delay, I'll ask him just to ready himself, and then he'll take us through the presentation for today. Over to you, Philip. Thank you.
Thank you, Sabu, and good morning to everybody from my side. Welcome to the session. I trust that you will at least learn something. I must be honest to say that I'm not an expert in your area of work, and please accept that. I hope that at the end of the session, you will not necessarily know exactly what product risk factors to look out for, but hopefully you will have a better awareness that you have to look at your product risks to be able to to compile your risk assessment for your institution. So as the experts in your area, you will be in a better position to know exactly which products cause a higher risk and which cause a lower risk. But okay, be that as it may, I'm going to go through the presentation, and then we will give you time at the end to ask questions, and we'll try to respond to those as best as we can. If we cannot answer your question, we will get back to you. We will also tell you where you can raise issues or questions with the FIC. So hopefully by the end of the session, we will be in a better position to at least have a better awareness of the risk factors. Okay, so today we will deal specifically with the product risks associated with like the FATF referred to you as trust and company service providers. And I know in South Africa and in the audience, there are probably mostly trust service providers as registered with us under item 2 of the FIC of Schedule 1 of the FIC Act. And I know that these services are also rendered by attorneys, and I know in some instances maybe even auditors or financial service providers. So if you are also registered under another item, you may also find some of the factors that we are going to talk about. You'll also find it useful, in relation to your other registration. Okay, so we will briefly talk about the Financial Action Task Force, which is our international body, where we get our rules and regulations and standards from. We will talk about how they see a risk assessment. We will talk about the mutual evaluation report that was issued on South Africa in October last year, and then we will get to the vulnerabilities of trust and company service providers products. Okay, so we've included for you here a few valuable links that you can use to get more information. There's a link to our guidance note 7, which is the guidance note about risks and how to do a sector risk risk assessment. There's also a link to the Act. If you do not have the latest version of the FIC Act, there's a link to the risk-based approach from FATF, the Financial Action Task Force, and how they identified risks for trust and company service providers. And then there's a link to our own sector risk assessment that we've published at the end of March, and which you've most probably already saw and already have had insight in. Okay, so those are the links that you may access through the presentation, which we Sabu can confirm it at the end, but I think we will make it available to everybody. Okay, so if we can start, South Africa is a member of the Financial Action Task Force, FATF as we refer to it. Now, FATF is the international body, intergovernmental body that sets standards and promotes effective implementation of legal, regulatory, and operational measures for combating money laundering, terrorist financing, and other related threats to the integrity of the international financial system. So as a member of the Financial Action Task Force, South Africa has to comply with its standards, and those standards are contained in what I refer to as the FATF recommendations. There are 40 FATF recommendations, and also those recommendations are then summarized in what I call immediate outcomes. There are 11 immediate outcomes, and we will talk a lot today about immediate outcome 4 and what that means, and also what the FATF said about South Africans' compliance with insofar as immediate outcome 4 and some of the recommendations are concerned. So the FATF recommendations are recognized as the international standard for combating of money laundering and the financing of terrorism and proliferation of weapons of mass destruction. So you'll find all these requirements that's in the FIC Act. You'll see that if you look at the FATF recommendations, you'll see that most of those sections in the FIC Act comes from the FATF recommendations. FATF has 37 countries. South Africa is the only full member in Africa. But they are also what we refer to as regional FATF-like organizations. And those regional bodies represent most major financial centers across the globe. Now, South Africa, as I said, is a member of the FATF, and we are also a member of the Eastern and Southern Africa Anti-Money Laundering Group, ISAMELAC, which we together with other countries in Eastern and Southern Africa, we are members of ISAMELAC. Now, as I said earlier, we have to comply with the FATF standards. They do what they refer to as mutual evaluations from time to time on their member countries. South Africa had its last mutual evaluation that was conducted in 2019. And due to COVID and you know, the whole situation around that, it took a bit longer to finalize the report. The report was published in October 2021. And we will talk about some of the highlights or lowlights, if you be honest, of the report a bit later. But the fact is that as a member country, South Africa was evaluated quite recently, and some shortcomings were identified, and we need to address those shortcomings. Okay. Further on the report, you would be able to find this report on the FIC website under publications or published. I think it's the heading. You'll also find it under the FATF website. If you type in South Africa, it'll give you access to the report, and then you can read the report. You know, if you are interested in that, the whole complete report. What we have in the slide here is the summary of you know, South Africa's performance, if you like, in terms of the different immediate outcomes and also in terms of the different recommendations. So as I said, there are 11 immediate outcomes. You can either be high, substantial, moderate, or low. Now, South Africa scored 3 lows and then 8 moderates in terms of these immediate outcomes. As I said earlier, we will talk today more about immediate outcome 4, and that refers to preventive measures. In other words, what steps or preventive measures are taken by the industry by sectors or sectors and individual institutions within the economy to address their money laundering and terror financing and proliferation financing risks. So for that, we scored a moderate, I'll explain to you some of the quotations and parts of the report, just to give you an idea of what the assessors said about South Africa. Then, and I'm not going to go to each and every one of these 40 recommendations, but you can have a score of C, which is compliant, LC, which is largely compliant, PC, which is partially compliant, or NC, which is non-compliant. So if we look at this just quickly, we have a few non-compliance, we have a few partially compliance, a few largely compliance, and we have, as I see, about 2 compliance scores. So obviously we've been told that we need to look at this and we need to fix our standards so that we can improve on these scores. Again, if you look at specifically what we're going to talk about today, we're going to discuss risks, and that to a large extent is dealt with in recommendation 1, which basically say that countries, sectors, and also individual institutions must understand and know their money laundering and terrorist financing and proliferation financing risks. They must understand it, and then they must, allocate their resources in accordance with that understanding of the risk. So on that, we scored a partially compliance, and that is across the board. Obviously, these assessors, when they do this assessment, they look at the country as a whole. It's not a thick assessment. They look at the supervisory bodies where there are supervisory bodies. They look at individual institutions. They look at law enforcement agencies, and all of that is taken into consideration when this assessment is done and when this report is then issued. Okay, so without going into all the details, as I said, you are welcome to read the report, and then this provides you as a summary of some of the findings from the report. Okay, more on the findings, specifically with regard to immediate outcome 4, which, as I said, is measures, that's preventative measures that's taken by the institutions to address their money laundering and terrorist financing risks. So the risk-based approach to customer due diligence, business risk assessments, and many other obligations for key preventative measures are not necessarily in place. That's one of the findings of the report, that we do not follow in all instances a proper risk-based approach. And that relates to the understanding and obtaining of client information, ongoing due diligence, politically exposed persons, and beneficial ownership. So what FATF is saying is that, with all these instances, you need to follow a risk-based approach. And the logic behind it is that if you understand your money laundering, terror financing risks, then you can allocate your resources in accordance with that understanding of the risk, and you would be more efficient in addressing those risks and in introducing mitigating measures to address these risk areas. So the report also referred to the fact that the risk assessments must not be static, and they say they are static and reactive rather than dynamic, and may miss important trigger events, incidents, and structural changes to threats and vulnerabilities. And they refer, for example, to trends and patterns following the Zondo Commission subpoenas and media coverage and related developments and the introduction of new statutory requirements. They also say that DNFPPs and those referred to designated non-financial businesses and professions And in South Africa, that includes trust service providers. It also includes attorneys, estate agents, gambling institutions, motor vehicle dealers, Kruger dealers. I think that's about it. So in other words, the non-financial businesses, non-banks, non-insurers, non-unit trust companies, all the non-financial institutions are referred to as DNFPPs. So the assessor said that the DNFPP's risk-based approach is lacking a business risk assessment. So they didn't properly do an assessment of their business risks, their transactions and product and overall business risks. It's lacking risk-based approach is lacking new products and processes risk assessment. In other words, what they're saying is that whenever you introduce a new product or a new service, you have to do a proper risk assessment in terms of money laundering and terrorist financing risks. And they also criticize the client level risk assessment that's done by the DNFPPs. The report further says that compliance with the rules-based requirement is not the only requirement. So they did acknowledge in some instances that we follow a rules-based approach to a certain extent, and we haven't. And the criticism is that we haven't moved from a rules-based approach in all instances to a risk-based approach. Now, you would probably know that the FIC Act was amended in 2017 with effect from I think the 2nd of October 2017, and that amendment introduced a risk-based approach and moved away from the previous rules-based approach. But obviously, it takes time for institutions to get used to this and to actually implement it, and that was one of the points of criticism in the mutual evaluation report. They said the risk-based approach must be applied, taking account of various risk factors. And we'll get to some of the risk factors a bit later. And then obviously, as I said, the purpose of a risk-based approach is that you are able then to, if you understand your risk and you know your risk areas, that you are able to introduce enhanced transaction monitoring and enhanced due diligence where high risk is identified. So you can allocate your resources in accordance with the higher risk areas and then spend less time and effort on the lower risk areas, which is supposed then to make you more efficient. And the report says that accountable institutions seem to consider a limited set of risk factors or indicators in assessing money laundering and terrorist financing risk. For example, the PEP status, and PEP refers to politically exposed persons. The PEP status of a prospective client is often the only or one in few risk factors considered when determining client risk profiles, particularly at the onboarding stage. And I think we see that in practice as well. Not only the fact that client risk is limited to PEPs, but also to a large extent in some sectors, I've seen that they concentrate a lot on client risks and not necessarily addressing all the other risk areas like geographic risk and product risk and services and transactions and delivery channels and so on. So to a large extent, there's a lot of and I can say, I've seen it, for example, in the estate agency sector, that they focus a lot on the risks of clients, and it's correct. You have to look at client risk, but you must not leave all the other risk areas. You must also look at those other risk areas. Okay, so that's just some of the findings in the report. More findings. There were findings about beneficial ownership, criticism about our how we deal with beneficial ownership. And as with the risk requirements or risk-based approach, beneficial ownership also became enforceable in 2017. And the report acknowledged that the Prudential Authority and the FIC observes that the beneficial owners recorded is not always a natural person. And if you look at the FIC Act, Section 21B, capital B, the requirement is actually to get to the ultimate beneficial owner, which is supposed to be an individual person, you know, and then to identify and verify that person, so that you can see who is the warm body behind the corporate veil. The report identified as a challenge the lack of transparency in corporates where public information is available. It is utilized, but it's not necessarily, it cannot always be verified. Then there is self-declaration that's done by the client, and information on group structures, financial statements, voting rights, attestations from accountants or auditors. All that is used, and it's good that it's used, but it's indirect information regarding to beneficial ownership. So they did criticize our you know, dealing of beneficial ownership. Okay, then if we move further, I just want to give you a very quick recap or explanation of what a risk-based approach entails. We've already touched on it, but I'm going to give you some more pointers to that. So South Africa introduced in 2017, we included Section 42 in the FIC Act. Section 42 deals with a risk management and compliance program, and it is very specific on what should be included in a risk management and compliance program. And the first thing in Section 42(2)(a, it basically says that institutions must be able to identify, assess, monitor, mitigate, and manage the risk that the provision of goods and services by the institution may involve or facilitate money laundering or terrorist financing. So if you look at the first two, identify and assess, that is in line with the FATF recommendation 1 and also with immediate outcome 1, where it is required that all institutions must understand their risk. To be able to identify and assess your risk, you need to understand what are your risks, where are your risk areas, where do you have to spend more time and effort in to mitigate and manage the risk areas. All of this must be clearly documented in your sector risk, in your risk management and compliance program, and you have to have a proper understanding of your inherent money laundering and terrorist financing risks. If we talk about inherent risks, it means risks before any mitigation or management actions were taken. In other words, the raw risk, if I can call it that, those are referred to as your inherent money laundering and terrorist financing risk. Once you've identified, you understand it, you have to implement reasonable measures that is proportionate to these risks areas. And that's one of the differences to the risk-based approach as opposed to the previous rules-based approach. With the rules-based approach, it was very specific. You had to get certain documents, for example, from your clients, irrespective of whether it's a high-risk client or a low-risk client. So the risk-based approach gives the institutions more discretion and allows them the freedom, if I can call it that, to apply a risk-based approach and to then also apply the mitigating circumstances in accordance with the risk identified. So you don't have to get all the information from everybody, but you also cannot regard everybody as low risk. But you will have low risk clients and you will have high risk clients, and you have to arrange your actions in accordance with that. Accounting institutions must be able to assess the risk involved, and they must be able to take informed decisions on the basis of its risk assessment as to the appropriate methods or controls and levels of verification that should be applied in a given circumstance. So obviously, if it's a complex client with a very complex structure, you may want to spend more time and effort on identifying and verifying that client as opposed to a natural person who's entering into a small transaction with you. Okay, the risk areas that we looked at, and you'll find this also in our PCs, or in our guidance note 7, products and services risk, and that's the area where we will spend more time on today. Then the delivery channels, geographic areas, client types, and then other factors. So if we look at the products and services, some of the things that you need to consider is third-party payments, involvement of third parties payments into or out to third parties, whether the product or service makes provision for cash payments, whether there's a cross-border flow of money, the duration of relationship or the transaction. Is it a long-term relationship? Is it a once-off transaction? And then on delivery channels, is it a direct relationship? You work through an intermediary or a third party? Is it a face-to-face relationship, or is it, in terms of our, or with our new technology, a relationship that maybe you do not meet the client on a face-to-face basis ever? Then on geographic risk areas that you need to take into consideration, is the client from a foreign jurisdiction? Is it the client from a high-risk country? What is the situation regarding client confidentiality in those countries? What is the situation with regard to regulatory oversight? Is it a country that is regarded by FATF as a high-risk country, or a country with low anti-money laundering standards? Is it a country that's maybe subject to high secrecy provisions? But not only the country where the client is from, you also need to look at the area where the money is coming from, and as I said, where the client is coming from, where the products that's provided is coming from, and so on. And it's not only international, there's also local geographic risk areas, and may not specifically be applicable to you, but in some instances, institutions that are closer to borders and so on can possibly be regarded as higher risk within South Africa. Okay, then the client risk, as I said earlier, a lot of institutions focus a lot on that. You need to look at whether it's a natural or legal person, if it's a legal person, whether the structure is a complex one, your politically exposed people, people that are prominent in society. You need to look at the media reports, whether there's been any money laundering findings about this person, or not only money laundering, fraud, corruption, all of that, on this person or on a family member or a close associate. And then also transactional patterns. Does it add up and make economic sense if you look at who the client is and what is his patterns of transacting with you? Then other factors that needs to be taken into consideration is the money laundering approach that is taken by the institution, or if it's an institutional client by that client, whether there's been any sanctions that was issued, what is the strategy, whether there's been any regulatory fines from the client, or whether the client was fined, or whether the institutions in that sector was maybe fined, whether there's any learnings or typologies that you can consider, that will improve your understanding of the risk. And then also things like media, media reports, not specifically on a client, but on in general on risk areas and so on. Okay, in this slide, we have an example, and I must stress it's only an example. It's not the actual risk score suggested by the FIC, as we said in the beginning. But on these different areas, you can typically have a client type, which is a natural person, where we can then allocate the risk score of 1. Legal entity, you can allocate the risk score of 2. If it's a very complex international client, you may want to allocate the risk score of 3. Product types, I see that setting up of a trust is we've regarded that as very high. But it may not be. It depends on what trust it is. But that is for you to use your discretion to decide that. And then geographic area, if it's North Korean client, it may be a 3, or South African client, maybe a 1 or a 2. Delivery channels, 3 for non-face-to-face, 1 for face-to-face. And then technology. If it's a client that's that you onboarded through technological means, it may be a risk rating of 2. But if it's a foreign company, it may be a risk rating of 3. And again, this is just an example. It's just a way in which you can decide to rate your risks using these different risk areas. In our sector risk assessment that we've published, we've included all this, and we've also included transaction risks, which refers to things like the use of cash and the involvement of third parties and so on. Okay, so then we will move over to specific risk factors of trust and company service providers in terms of their product risks. And as I said, again, I need to make this disclaimer. I'm not an expert in this. The purpose is not to give you a complete list of all these risk factors, but rather to create awareness that you need to be alert, and you need to take into consideration money laundering and terrorist financing risks. Okay, so I'm going to start with general product risk factors as we have it in Guidance Note 7. So these are not specific to trust service providers, but rather general factors. So if it's not applicable to you, then I understand that. We've included this in Guidance Note 7, which is obviously applicable to all our accountable institutions, to make them aware of risk areas that they need to look out for in terms of product risks. So the first thing that we have there is, to what extent does the product provide anonymity to the client? And I think in your instance, you need to ask that, but you also need to ask whether the eventual or the ultimate beneficiary of a trust, for example, would be able to hide his identity through this product or through this arrangement that you are then involved in setting up. Does the product enable third parties who are not known to the institution to make use of it? So again, we've already referred to that, the use of third parties. People may be introducing the client, or people who are acting on behalf of the client. Do you know who that is? And are you able to assess the risk associated with such an arrangement? And I think one must recognize that there's obviously there's a need by accountable institutions across the board to make it easier for their clients to do business with them. And that's fine. That's part of your service offering and so on. But in doing that, you must also at all times consider the possible money laundering and terrorist financing risks associated with that. The next question in Guidance Note 7 is, does the product allow for third-party payments? And that, again, I would imagine payments into the institution, as well as payments by the institution to third parties. Is there another accountable institution involved in the usage of the product? In your instance, it might be a financial service provider that refers a client to yourself, asking you to assist with setting up a trust structure. So that financial service provider is then another accountable institution. And do you know that, whether that institution is properly registered? Do you know whether that institution has done a proper customer due diligence on this client, especially if you want to rely on that information? Are you sure then that such an accountable institution has gone through all the loops to make sure that the client is properly identified and verified? Next question is, can the product be funded with cash, or must it be funded only by way of a transfer to or from another financial institution? Obviously, cash is regarded as a bit higher risk due to the possibility that it might come from an area that you don't know where it's coming from. So whether it can be funded with cash is a question that you need to consider. Then how easily and quickly can funds be converted to cash? And in some instances, obviously, some clients deal with cash, and the cash is their business, like retailers and so on. So cash is not necessarily always an indication of money laundering, but the risk there needs to just be considered. You need to look at whether there's a cross-border transfer of funds, whether there's a possibility for that. And if somebody is a serious criminal and is a very knowledgeable criminal, and we've seen that in the past, they often want to move their money out of the country. So if there's a possibility of that, you need to be, take that into consideration as well. Is the offering of the product subject to regulatory approval and or reporting? Again, you may have reference from a financial service provider. They provide services that are subject to regulatory approvals, and you need to consider whether whatever you do is maybe subject to regulatory approval, and whether that approval was properly obtained and is in place. What does the product enablement processes entail, and to what extent does it include additional checks such as credit approvals, disclosure of information, legal agreements, licensing, regulatory approvals, registration, or involvement of legal professionals? You can even maybe add auditors, also here. So those are just some of the things that you need to consider in general. Okay. To continue on that, to what extent is the usage of the product subject to parameters set by institutions? For example, value limits, duration limits, transaction limits, etc. Or to what extent is the usage of the product subject to penalties when certain conditions are not adhered to? And just to again stress, this is general. It's from our guidance note 7, and it doesn't necessarily apply to all, but these are just some of the things that you may want to consider. Is the usage of the product subject to reporting to regulators and or to the market? Does historic transaction monitoring information indicate a lower or higher prevalence of abuse of the product for money laundering or terrorist financing purposes, or for corruption and bribery and those sort of criminal activities? So if you know that certain trusts has been in the past been involved with bribery and with corruption and so on, then obviously you need to take additional care and diligence to make sure that that is covered, that additional risk is covered in your risk assessment. What is the intended target market segment for the product? For example, entry-level retail or high net worth individuals. And I think this is very applicable in your world, because and it maybe goes a little bit into client risk, but obviously in your environment, setting up of a simple testamentary trust would be totally different from setting up a trust for a very wealthy international businessman who owns a few companies, and some of these companies are linked to the trust or are beneficiaries to the trust and so on. So this entry-level retail or high net worth individuals is a very important factor that needs to be taken into consideration if you look at the product risk. Larger corporates, do we involve larger corporates in this product? Do we involve state-owned companies, or who's the client involved here, and for which market segment does the product then caters for? Does it cater for specific industry sectors or professions, or is it a general thing that's provided to everybody? Does it cater for salaried or self-employed individuals? If it's a salaried individual and it's a monthly payment, then it might be lower risk than when it's for self-employed individuals, and the transactional patterns is not, you cannot always guarantee that, or it's not, you're not able to foresee what the exact transactional patterns is. Then it may be a higher risk. You need to then apply additional measures to make sure that that you have everything in place. Minors, we've mentioned minors in guidance note 7, and I think that's also something that's applicable in your world, because obviously some instances you would set up trusts for minors. Apologies for that. But in some instances, it may also be that minors are used to hide the identity of the ultimate beneficial owners. Then is the usage of a product subject to additional scrutiny from a market abuse or consumer protection perspective? You will know that in some instances, consumer protection is important. There's the act, what is it, the Consumer Protection Act, that is applicable. So you need to be aware of the products and whether it enables or allows that. Okay, if we move over to the next slide, you need to look at what is the time duration for the conversion of funds, property, etc. through the usage of the product. Is the product an industry regulated product? Now, in some instances, there are only industry regulated products. In some instances, it's not necessarily the case. Does the product allow for the flow of physical cash? We've already referred to that, whether you pay out or receive physical cash. Are there specific conditions that must be met or events that must happen for clients to have access to funds, properties, etc.? And if they are, what are they, and does it make sense? All those are some of the factors that you need to take into consideration. Does the usage of the product entail structured transactions such as periodic payments at fixed intervals, or does it facilitate an unstructured flow of funds? I referred to that when we talked about salaried versus self-employed clients. And, if it's a periodic payment, let's say it's the renting of a flat by an estate agent is involved in that, or in your instance, the trust that you are involved in receives rental income every month. It's a bit easier maybe to monitor that as opposed to a trust that's set up for business purposes and that receives funds on an irregular basis from different client types, different amounts, different receipt of those funds. The same applies obviously to the payout of funds. Okay, further factors from guidance note 7. What is the transaction volume facilitated by the product? I think it goes without saying that very high amounts are probably more risky in terms of money laundering and terrorist financing, well, especially money laundering, as opposed to lower risk or lower value transactions. However, if you look at the terror financing risk, lower apologies, lower transactions may be just as risky for terrorist financing. Does the product have a cooling off period, which allows for a contract to be cancelled without much formality and the refund of monies paid? That's the classic way of laundering money. If you have a situation where you pay funds into an attorney's trust account or a trust service provider's trust account, and you are able to get that money back without the transaction having taken place, then you have a receipt of money from an attorney or a trust service provider or an estate agent for that matter, and in a way that money is then cleaned. So whether the product have a cooling off period is very important, because cooling off periods are often used for laundering funds and to hide the true identity of where money comes from. Other products offering a short-term or longer-term contractual relationship. If you look at the FIC Act, you'll see that there are different requirements for a once-off transaction as opposed to a business relationship. So you need to also take into consideration whether, if it is a business relationship, whether it's a long-term relationship or a shorter-term relationship. So that will form part of your risk assessment. Do products require a payment from a same name account or facility to facilitate the opening of a product, or is it possible to receive money from a third party which you don't necessarily know who it is? Okay, so far these are all the product risk factors that we've identified in our guidance note 7 issued by the FIC, which is available on the FIC's website under guidance if you want to have a look there. And as I said in the beginning, this applies to all businesses. So it's for you to look at these factors and to consider whether it is applicable to your business and your institutions. So what we will look at now is the factors that were identified by the Financial Action Task Force in the document, which we've also, it's one of the documents which we've provided a link to you in the beginning of this presentation. Where FATF issued this risk-based approach for trust company service providers products. And it deals then with those risk areas that were identified by the FATF as areas specifically for trust and company service providers. And the fact that it was identified by FATF, again, I must put in this disclaimer, it's also not necessarily applicable to situations in South Africa. And some of these things you may say to me doesn't apply to us, but it applies in general to trust and company service providers. And I must also say that if you say to me, but in South Africa you need to get approval from the Master of the High Court, and you have to go through specific processes and procedures to register a trust. That is true, and that, I guess, to a certain extent reduce the risk. However, trust and any other product for that matter can be abused for money launderers and terrorist financiers, even if everything in relation to the registration thereof is in place and it's properly done and it's above board, even then, you know, those products or institutions can still be abused, you know, by criminals. So keep in mind that even if you have complied with all the legal requirements, doesn't mean that trust cannot and will never be abused by criminals to launder their illicit funds. Okay, so back to the FATF identified factors. They said the use of pooled client accounts or safe custody of client money or assets or bearer shares without justification is a higher risk area. So I'm not sure if you're involved in that. As far as I know, in South Africa, we do not really have bearer shares, but things like the safe custody of client money or assets may, without a proper explanation, may point to clients trying to hide those assets. Then it refers to situations where advice on the setting up of legal persons or legal arrangements may be misused to obscure ownership or real economic purpose, including setting up of trusts, companies, or other legal entities, or change of name, corporate seat, or establishment complex group structures. This might include advising in relation to a discretionary trust that gives the trustees discretionary power to name a class of beneficiary that does not include the real beneficiaries. For example, naming a charity as a sole discretionary beneficiary initially with a view to adding the real beneficiaries at a later stage. It might also include situations where a trust is set up for the purposes of managing shares in the company with the intention of making it more difficult to determine the beneficiaries of assets managed by the trust. So this is a mouthful, but I think if you go on Google and you Google money laundering risks of trust, the one thing that stands out and that will come up is the fact that it's often used to hide the identity, and people are hiding behind trusts to hide their assets. And they're not necessarily criminals. They might want to hide their assets from predators or from ex-wife or children or, you know, other family members or whatever. But and it also comes out if you look at the whole issue of, you know, these secret jurisdictions and the Panama Papers and the Pandora Papers and so on. A lot of those arrangements were set up with the aim of hiding the identity of clients. So so this is very important, you know, if you break down this whole bullet point, to look at you know, the reason why people want to establish a complex group structure, or the reason why people want to establish a trust, or maybe an international trust. Those are the sort of things that you need to look out for. You need to make sure that you know, the purpose of this is not to launder funds or to hide funds or to evade tax, paying of tax. And there's a difference between you know, setting up structures to make your tax affairs more efficient, which is above board, or to hide some income. And as trust service providers, you need to be aware of the possibility that this might be done. You need to know how to deal with it, and you need to know what impact that has on your risk assessment of your products and your clients. Okay, FATF also said that in the case of a trust unexplained, where explanation is required or is warranted, an unexplained nature of classes of beneficiaries and acting trustees of such a trust. In other words, if you provide services as a trustee, for example, in inverted commas, an independent trustee of a family trust or something like that, or a business trust, have a look at who are, you know, identified as beneficiaries and acting trustees and so on, your other trustee members. And isn't necessary to explain that, doesn't make sense. in terms of the setup and the structure of the trust. Does it make sense to have specific people or classes of beneficiaries? So those are the issues that you need to be on the lookout for. Services where trust companies may in practice represent or assure the client's standing, reputation, and credibility to third parties without the commensurate knowledge of the client's affairs. So if you are asked to identify or to confirm the reputation and credibility of a third party, if I was in your position, I would be very reluctant to do that unless I've done a proper assessment of that person. Yeah, so obviously when that is done, you need to take the necessary actions to make sure that you are familiar with this person and you are comfortable, providing such a confirmation. Do you provide any services that are capable of concealing beneficial ownership from competent authorities? And I think I've already referred to that. If you look at, for example, the Panama Papers and the Pandora Papers and all these international trust, especially in high secrecy jurisdictions, that is something that you need to look out for, whether it's not perhaps aimed at concealing the beneficial ownership from competent authorities. And that would include tax authorities, would include law enforcement agencies, would include financial intelligence units, and so on. Do you provide services that have deliberately provided or depend upon more anonymity in relation to the client's identity or regarding other participants than is normal under the circumstances and in the experience of the TCSPs? As I said in the beginning, you guys have experience and you understand your products and your services much better than the FIC does. So you have to also sometimes rely on your experience to decide whether something appears to be a bit fishy and whether you need to take additional steps to identify and verify a client, to monitor a transaction, and so on. Then the use of virtual assets. There is a new means of payment which is, I guess, becoming more popular in the world, all over the world. So that is also something that you need to just look out for and be aware of the additional risk that causes for the products that you provide, the services that you provide. Any other anonymous means of payments and wealth transfer within the transaction without apparent legal, tax, business, economic, or other legitimate reasons. Transactions using unusual means of payment or exchange of assets. Obviously, you can have, I guess, all sorts of arrangements in a contract, which is not necessarily illegal, but which may just prompt you to take additional care and diligence. The postponement of a payment for an asset or service delivered immediately to a date far from the moment at which payment would normally be expected to occur without appropriate assurances that payment will be made. Remember, money laundering is about the hiding of criminal or assets derived from criminal activities, but it's also about, or it's done by transferring assets or money from one person to the other. So it's possible that the postponement of a payment may result in that payment never happening, which means then that you've transferred assets from one person to the other person, thereby hiding the origin of that asset, or involving somebody who's not involved in that transaction, and so it's more difficult for authorities then to follow the money and to pick up where this money eventually ended up. Successive capital or other contributions in a short period of time to the same company or legal arrangement with no apparent legal, tax, business, economic, or other legitimate reasons. whenever you do a transaction, that applies to all accountable institutions. One of the things you must do is to ask yourself whether this transaction makes sense, and whether the client, asking for this service or buying this product, investing in this product, whether that makes sense for that client to do that. If it doesn't make sense, then you can take additional steps to make sure that everything is above board. Acquisition of businesses in liquidation with no apparent legal, tax, business, economic, or other legitimate reasons. As I say, again, it might be transfer of money from one person or one entity to another. Then the power of representation given in unusual conditions, for example, when it is granted in relation to specific assets. The stated reasons for these conditions are unclear or illogical. Always ask yourself whether any arrangement, any request from a client makes economic sense, and whether there's a proper, obvious reason for it, or whether it might be aimed at hiding, certain assets. You have to look at transactions involving closely connected persons and for which the client and or its financial advisors provide inconsistent or irrational explanations and are subsequently unwilling or unable to explain by reference to legal, tax, business, economic, or other legitimate reasons. If you look at the list of politically exposed persons, for example, which you will find in Schedule 3A and 3B of the FIC Act, you'll see that they talk about not only about the politicians and the businessmen, but also about people closely related to them. So you have to look at closely connected persons also when it comes to your clients. Situations where a nominee is being used, for example, a friend or a family member is named as owner of the property or assets, where it is clear that the friend or family member is receiving instructions from the beneficial owner with no apparent legal, tax, business, economic, or other legitimate reasons. And I think it has happened in the past that criminals are enjoying, as beneficiary of, for example, a trust, are enjoying these assets that they've acquired by criminal means, but it doesn't belong to them. Technically it doesn't belong to them, but they have oversight over it, and they enjoy the fruits of those criminal activity or criminal activities. So whenever there's a nominee, or wherever there's a possibility that a beneficiary, for example, may not be named as such, or may through somebody else, enjoy the benefits, then you need to be aware of that. You need to look out for that. Commercial, private, or real property transactions or services to be carried out by the trust company or other legal entity with no apparent legitimate business, economic, tax, family, governance, or legal reasons. Again, look at the business of the trust and the business, the clients that are involved, and so on. Products and services that are inherently provided more anonymity or confidentiality without a legitimate purpose. What are the products and services that you provide, and does it enable the client to be anonymous? In this slide, I think it talks more about trade-based money laundering, but if you are involved in a trust that are a business trust or that runs a business, then this might be applicable. The existence of suspicious or fraudulent transactions or transactions that are improperly accounted for, including over invoicing of goods or services, multiple invoicing of the same goods or services, falsely described goods or services where there's, for example, over or under shipment, if there are exports or imports involved, multiple trading of goods or services. These are all things that you need to take into consideration when the trust might be involved in business activities. And before we get to de-risking, I just want to say that in my understanding of your sector, and I might be wrong, but you can be involved in the administration of a trust in the sense of assisting with the setting it up and doing all the admin work around it, which obviously you need to also ask all these questions and make sure that the trust is set up for proper business purposes or tax purposes, without trying to avoid paying tax or illegally avoid paying tax. So you can either do that, or you can also be involved as a trustee. Now, it is my understanding that in some instances, a trust service provider will be asked to act as trustee to assist the other trustees, because they don't necessarily have the legal background or the investment knowledge or the administrative knowledge that is required to run this. Now, in both these circumstances, you'll have to make sure that everything with regard to the trust is above board. If you are involved as a trustee, let's call it the independent trustee. And I don't think it's necessarily the right term, but as a trustee who are supposed to assist the trustees with your knowledge and expertise, then I think it's important that whenever that trust deals with clients, whether it is the trust maybe has a property, or the trust is involved in a business, or the trust, whatever the purpose of that trust is, and whatever monies that trust receives and pay out, you as the one of the trustees has a duty to make sure that the clients that the trust are dealing with, the products that the trust provide, the services that the trust provide, that all of that is properly considered and properly taken into consideration, whether it might result in money laundering or terrorist financing. So if your trust deals with a client, then you need to know who that client is and what's the purpose of that transaction, as we have now explained. And I think that is very important, because as one of the trustees, you need to see whether your own whether the other trustees of that trust is acting above board, but also whether the clients and other people that are involved in the trust, beneficiaries, founder, whether all of them are acting in good faith. And that is very important. I mean, I think trust service providers are very important gatekeepers, as we call it, in the economy, to make us aware of illegal transactions, or transactions that are aimed at hiding beneficiaries or at hiding certain assets. Okay, so that is my understanding of your business, and all I want to say is that whether it's only setting up the trust or whether it's involvement as a trustee on an ongoing basis, on a longer term basis, those are the things that you must please look out for and need to report to us if necessary. Okay, just one slide about de-risking. Now, de-risking refers to institutions not continuing with a business relationship. And there's been a lot of talk lately about de-risking, and you would have seen there were even newspaper articles about banks that didn't want to do business with certain people and so on. Now we in the FIC has always not necessarily been in favor of de-risking, but however it is the institution's own decision on whether to do business with an individual or with a client or not. But it's not necessarily considered effective or adequate risk management if an accountable institution decides to de-risk a client for the mere fact that it poses a higher risk in respect of money laundering and terrorist financing. So that's why the risk-based approach is there. The politicians also need bank accounts and, you know, people to advise them on trusts and legal issues and so on. The rich international businessmen also need that advice. And there's nothing wrong with providing that advice. However, you need to include in your risk assessment all the potential higher risk associated with those clients and with those type of transactions. And if there is a problem that's identified, you need to then make a report and carry on with the transaction. In fact, the FIC Act clearly say that if you come across something that's suspicious, you need to make a report, but you also need to continue with the transaction. If an accountable institution, and that's any accountable institution, makes a decision to not onboard a certain class of clients, the accountable institution must be able to demonstrate the application of a risk-based approach in terms of which several factors have been considered and not just one. So maybe a high-risk politician buying a low-risk product or insurance policy or something like that, it doesn't mean that that transaction is always high risk. But you have to take into consideration different factors. Okay, then it's just to say it's a thick view that the accountable institution would have to demonstrate why the risk is so high or severe that the accountable institution do not have appetite to onboard a specific client or provide a specific service. And one of the reasons for that is in the next bullet is to say that ineffective application of de-risking can cause inadvertent consequences, including the loss of valuable information through regulatory reporting due to the FIC. So obviously, if somebody or some institution is very suspicious, keeping that person in the net and in the economy would enable us to better monitor transactions that involves that person or entity. So just to say that I don't think the FIC is in a position to definitely say to people you have to do business with everybody. However, I mean it's your business to do business with people. I mean you have to continue with your business. The fact is you have to just keep in mind there is the FIC Act, there is something like money laundering, there is something like a risk-based approach, which you can then use to cover you and to make sure that you do not do business with criminals. It's also obviously not very good for your reputation if you are involved in criminal activities or if you provide certain services or products to criminals. I mean, you can just imagine what the newspaper articles would say, and it would not necessarily be good for your own reputation. So that you also need to take into consideration. And that is basically it. As far as the presentation is concerned, we can look at answering a few questions if there are, and then yeah, have a look at those documents that we've provided links to. That'll also give you a much better idea of what to look out for insofar as your products are concerned. But yes, Subu, I'm going to go over to you, and then you can tell me whether there's been any questions, and we can try and address it as far as possible. If we cannot answer, then we will come back to you. Thanks.
Thank you very much. Ecco, quello che scarica oh, no problem. Philip, we don't have any questions. It's a funny part, but we will request our colleagues just to go back to the Q&A tab on the top right of their computer and complete a post-session questionnaire. So just take 3 minutes to complete this questionnaire. So I'll just keep quiet for a few seconds, and then while you are completing the questionnaire. So please go back to your Q&A tab and then complete the post-session questionnaire. On the same tab, please also forward any questions that you might like us to respond to. At the moment, we're not having any questions, which is the funny part, that we finished and completed the session without any questions. So it simply means that Philip was really good in his explanation, and then everything was covered during the session. So I'll hold my peace for a few seconds, and then I'll request you colleagues just complete the post-session questionnaire that is attached on the Q&A tab.
Sabu, while we are giving the people opportunity to respond, I think before we close the session, you can maybe just also explain PQP process and the call center and so on, just to if somebody thinks about something that he or she wanted to ask, and yeah, I think you must just explain that before we close.
Thank you very much, Philip. Also, colleagues, if maybe at a later stage you have questions that maybe we did not cover on our presentation, please feel free to call us on our contact center. I'll just ask Philip to scroll down on his slides, and then so that he goes to the last slide. Okay, so we have a PQP system, colleagues, and then that's where you can forward the questions that might have not been covered during our session. And then, or you can call our contact center on the screen that's available or that's showing on your monitors right now, where we will be dealing with any questions that you might have in regards to money laundering, terrorist financing, or proliferation financing. So you can call us on 012-641-6000. So that's an open line. You can call us at any given moment or any given time. The other way that you can forward questions or concerns or queries to us is through our public query portal, which is available on our website, which is www.fic.gov.za. You log into our website, and then you go to our public query portal, and then that's where you will log a query, and we'll come back to you as soon as we can. But the quickest way in most instances, and then if it's a query that you can answer a bit quicker, you can just give us a call on 012-641-6000. And colleagues, as I said a bit earlier again, please complete our post-session questionnaire, which is attached on our Q&A tab. And then we are still not receiving any questions, Philip. Today is a different day. It's as if we don't have any questions at all, not even a single question. I think the topic has been covered vastly and widely in the past week, and then we were able to address a lot of questions. And then should there be any questions, and the PQP or public compliance query platform will be followed, or people will give us a call on the contact center. With all that said, colleagues, both links are open. And then for the attendance register, please don't forget to complete the attendance register so that we'll be able to send you this presentation that was conducted today. And then we'll also put the videos of all the sessions that we had during the week on our YouTube channel. So when you have time and then you want to just recap, or you want to go back and check something that you could have forgotten from the presentation, please go to our YouTube channel and then watch the videos from our YouTube channel. With that said, I think that now we will close the session. We don't see any questions again. The only problem is that we couldn't complete, people could not complete the register a bit earlier. And then Philip, that's it from my side. And then I'd like to thank everyone. Back to you, Philip. We can close the session.
From my side, thank you for attending. I'm not sure why there aren't questions, but I hope that we've contributed in giving you, as I said earlier, not a complete list of all the things that you need to look out for, but just a better awareness, because you are in a better position, a much better position than the FIC. You understand your products, you understand your services that you provide to your clients. So just keep in mind at all times that there are, money laundering is a reality. Even terrorist financing is a reality, especially when you deal with charitable organizations and these sort of things. Make sure that, the money ends up where it's supposed to end up. If you just spend like an hour or so to read about things like, the Panama Papers and the Pandora Papers and all these international criminal activities, you'll find a lot of information that'll show you that, this is a reality and that these are things that you need to look out for. So please be aware of it. And whenever you provide service, a new service, or even your existing services and products, when you deal with new clients, when you bring into or enter into new markets or new products or new ways of doing business, ask yourself whether that perhaps does not contribute or could not perhaps contribute to clients hiding their identity or to funds being laundered through your organization or with your organization's assistance. So please, just be on the alert and be careful not to do business with criminals, also for your own sake and to protect your own reputation. Thanks again for listening to us. And as I said earlier, you are more than welcome to pose further questions to the FIC if you have, or if you think about something later. We will try to address it as best as we can by making use of the PQP process, or the and that you'll find under contact us on our website or contacting the call center. So thank you very much for listening, and good luck with your business. Thanks. Bye-bye.